So now we shift to Thessaloniki. You have the great joy and pleasure and honor to have a discourse with Mr. Michail Pikramenos, who has honored us in the past as well with his presence in the tax forum that was held in Thessaloniki. Mr. Pikramenos has a dual capacity because on one hand, he is a supreme judge. He is vice president of the state court, heading the second department of the state court, which is as well known. Hears all the tax affairs. And at the same time, he is a scholar. He is an assistant professor in the law school of Aristotelion Panepistimion in administrative law. Not only that, a lot of other properties. He's an author, but I can't waste any valuable time to refer to all his capacities. Thank you, Mr. President, for your presence here. We will not dwell on the jurisprudence of your court, which is very interesting indeed. And it's a very important source for all of us involved with tax law. I would like, however, to dwell on practicalities, which of course have to do with quality of justice. And let me start from a comment on figures. We already spoke of figures in the Ministry of Justice with regard to the progress of hearings and the pending cases. I would like your comment on the subject. From what we see, the pending cases which have to be heard in the State Council from 2012 to date have shrunk by 60%. Respectively, we've seen a reduction with the various interventions in the administrative courts also up to 50%, in administrative first instance courts at 90%. In your department, however, that is the tax affairs, the tax cases, there has been an important reduction of the pending cases, but this does not exceed 30% in the reduction. That means that your division has too many cases, and the ratio with the other divisions of the court state is to the detriment of your division. Do I read things accurately? And if is that so, should something happen? Well, I warmly thank you for the invitation. First of all, it is the second time that I participated in this forum, and I have the opportunity to voice certain things on the operation of the court and this specific division of the court. It is true that the second division is the most burdened department of the court state. I have some figures to offer indicatively. From the 1st of January of 2016 to date, 22,000 cases have to be heard, of which 5,000 regarded the second division of the court state. And since we have 6 divisions plus the plenary session, you realize what's the huge burden upon the shoulders of the second division of the state court, which still holds the primal role to date. Suffices to mention that previous years and the pandemic year and this year, it's still far more burdened than the other division and with greater production. This is due to the fact that the subject, the taxation, is of huge interest for the state, of course. We have a series of demands for annulments on behalf of the state, which perhaps should perhaps not be heard because we have jurisprudence on many subjects. This is an issue that is the state having recourse to courts on cases that could be solved through jurisprudence. Furthermore, the second division is also the annulment department. I give you characteristically, we have the offset dues of local administration organizations that is in charge for us, and the issue of objective property values. There are also teams of of cases, which is still of concern under certain versions. The principle of mild penalty from the EU also appears in various cases. The complementary elements are also an important part. The offset use also cover a big part of our activity. All these are cases introduced to our division constantly under various forms. And this creates a responsibility for us, a responsibility for a more effective hearing. Suffices to say that last year our division issued 1,122 decisions, an important number if we bear into consideration there was also the pandemic that has started. This year have already reached 600 cases, always taking into consideration the parameter of the pandemic that has led to a great reduction of the hearings in court, because for large periods we were not come in session. That is, cases would be introduced, but the lawyers would not come, the barristers would not appear, and therefore there were postponements. Now, on the issue of postponements, which is a major issue highlighted by the press as well, of course, part of the annulments are to be we are accountable for those annulments due to the great workload and the degree of difficulty of the cases. It is a technical division par excellence with very difficult concepts we handle, deriving both from the European Union and our Constitution. But part of the responsibility and accountability is of lawyers. They ask annulments very often for reasons regarding perhaps the relations of barristers and solicitors with their customers on how they see a case evolves. And therefore, the burden for an effective operation of the justice lies on through three parameters. The first is the state. It was mentioned beforehand by the minister with regard to the evolutions that are in track. The second parameter are the judges. And the third parameter are the solicitors and barristers. And each parameter has an independent and heavy contribution. That means judges cannot say that since we do not have all infrastructure, we cannot produce work. Nor can lawyers say that since judges do not operate as they should, or the state doesn't offer what is necessary, we will not produce more work. Each one has one's own independent contribution and responsibility, and we are obliged to extinguish all the margins we have offered by the state and our potential. Thank you, Mr. President. Indeed, therefore, it's commonplace that the second division of the court is burdened with more cases than the other divisions and far more demanding cases. This is something that we have to keep in mind. We are not experts to offer solutions, but as you said, the cases for annulment, as it happened with the cases of competition were diverted elsewhere, perhaps the same should be done here so as to disperse the load, the workload. We absolutely agree. And with regard to postponements, lawyers as well understand part and share of our responsibility because we have witnessed indeed preposterous demands of for annulments by colleagues, and we must show the necessary spirit of cooperation so as to have progress in hearings. Now, let me revert to another issue. We know you have a very rich experience from participation in work teams. You have participated in the survey conducted by Ioannis for the renewal of the justice system. You have been the author on the time management in administrative courts. Could you please give us your condensed experience and a taste, if you like, from all the survey you have conducted and your participation in work teams? Thank you for this opportunity offered. Let us say that reforms is a continuous and constant evolution, never ceases, because problems change in forms. A turning point in my career was when I started the beginning of 2000 participating in European institutions. That was another world. International and European experiences drawn are amazing and give you the opportunity to think out of the box and therefore find new solutions. Quite important also was my mandate in the School of Judges, where in the last address I made in the Megaron Musikis, I said that the necessary element is the continuous lifelong training of judges. 16 months in the school does not suffice. A real judge's profile can be created when we have lifelong training and all degrees. The 30-year-old judge has other kind of life experiences than the 40-year-old or the 50-year-old. A seasoned judge perceives and grasps reality quite disparately, very differently from a young one. So that was an important step with the current bill for the School of Judges to have a lifelong training and focused on specific subjects, as is, for instance, the issue of the code of ethics for judges, which is extremely significant and has been greatly developed at global scale. Many countries have specific maps of code of ethics, and we follow suit at the right direction, I believe. The second point that I would like to underscore are infrastructure, and especially the clerical personnel. We're amongst the worst countries in the EU in the ratio of clerks to judges, far more judges than clerks. We need definitely boosting, not at large, of administrative staff. We need employees in IT, where digitization, in order to be supported, must have the appropriate infrastructure. That is, employees that can really handle IT. Now, with regard to the layout and special planning of courts, I participated in a study in 2007. Following my exposure abroad, modern evolutions dictate that we must have very strong and effective courts. The time of scattered small courts all over the sovereignty is obsolete. We want very strong courts that would be operating through IT as well and have video conferences and therefore have video hearings. I cannot forget an experience I had in 2014 where in the Council of Europe I saw a court venue with screens. Therefore, the venue was in Athens and the barrister was in Thessaloniki or Kos or Castellorizo or Crete, or you have it. We can save time and money and really contribute to the development of justice, exploiting the available means and giving the opportunity to implement the principle of vicinity through IT. Steps are already positive. I've heard from administrative courts using already this method of teleconferencing in order to come in contact with litigators that are in different cities and have no transfers. Another important element is the issue of the evaluation of judges. I suppose in the new code proposed there will be such a notion introduced. And the evaluation to date is very stereotyped, does not give the real picture of every judge. To my view, the evaluation should not be on a penalty basis. It should be primarily corrective and offering incentives. That is, the inspector should point out the positive and less positive elements and give a boost to younger judges to produce work. And last but not least, we're not interested only on numbers, we're also interested in quality in the justice. Therefore, the difficulty ratio of the cases handled by each judge is very important. And usually it's the tough cases that solve problems of broader interest and create jurisprudence for the case law, if you like, create case law for the broader society. Thank you, Mr. President. I keep the optimistic note that all these new technologies, the new spatial planning, digitization at large, will improve the performance of the judicial sector. I hope we will soon reach the goal set by the European Commission as well on the effectiveness of justice, as proclaimed by the Council of Europe. They do not want more than 2 years of hearing for any case. Let me greet you goodbye with a specific question where I do not expect your answer. It could be a subject for a new conference. The question, however, is whether we have the danger from too much of IT and automation for justice to lose its human face. We speak of automated process. It is an issue where this relation with the physical person of the judge is perhaps endangered. I just raise it as a philosophical query to Professor Pikramenos for future discussion in some other forum. This is an excellent question. This concerns mainly the AI department. Artificial intelligence is a next step, and there's a major issue to what extent we might be led to automated solutions and decisions. I know they work on this subject in the Council of Europe, and they try to find safeguards so as to limit it. A last comment from the previous discussions. I would like to point out that the judicial control is always a control of margins and limits. It's a law. It is an issue of constitution. A law can very well not be considered effective, but be indeed under the Constitution, what the Constitution stipulates, and the other way around. So justice has specific margin within which it may move. In no case can it substitute the legal power, which is the only power responsible for primary assessment of its regulations. Thank you, President, for your presence. Our greetings to the wonderful Thessaloniki. We hope to have you